My name is Eli Braun, and I am representing Lester Nygaard. My client has been accused of conspiracy and attempted armed robbery. Both of these claims are false, and the elements necessary to convict my client are weakly argued at best. Moving forward, I will be going through the counts individually and explaining how the necessary elements are not met in this case. I'm convinced that by the end of my closing statement, no reasonable juror would convict my client of these crimes. We're going to begin with element 1 of conspiracy. As I said, he is being charged with conspiracy and attempted armed robbery. Element 1 of conspiracy states that the defendant entered into the agreement with one or more people to commit the offense of armed robbery. This element is clearly not met in this case. There's vagueness surrounding the note that has been brought in for evidence. He could be going for a job. He could be doing a number of different things to try and get some money, but it's not clear what he's doing. As Peggy Nygaard stated, her husband is a big-time hunter. He also goes to shooting ranges often. How can you conclusively say that a man who has a gun near him, in his vehicle, is conspiring to commit armed robbery when there's no direct evidence and there's a completely plausible alternate scenario? He's a big-time hunter and he goes to shooting ranges. It's not shocking that he has a gun in his vehicle. Also, neither of the defendants have testified, and they are the only people who could conclusively say whether or not they conspired. Their eyewitness testimony is lacking in this case, and I just want it to be clear that their absence of testifying does not make them guilty in any way. The second element is the intent to commit armed robbery. This one I just want you to think about logically. If you were going to commit an armed robbery, would you be relaxed enough to fall asleep in the back of your vehicle? Is that how a normal person would react? Doesn't seem logical in any way to me. Third element, agreement that one or more of them would engage in armed robbery. There's simply not enough details to corroborate this story. Again, in this country, it's innocent until proven guilty, not the other way around. We don't assume someone's guilt just because we don't have all of the information, or some of that information is unattainable. In fact, in those cases, our judicial system finds those defendants not guilty. The fourth element is that one of the parties to the conspiracy committed an overt act in furtherance of the conspiracy. An overt act, defined by this court, is an act done by one of the parties to carry out the intent of the conspiracy, and it must be a step towards the execution of the conspiracy. This element just simply doesn't work. In this case, an overt act would be something like getting out of the car with your gun and walking towards the store, and then someone stopped you, or maybe if they had just walked to the store in the first place, someone stopping them. But just being in your car with a gun is not enough. I mean, if it's illegal for people to carry guns in their cars, then how can hunters possibly get out to land in which they hunt? Same thing goes with people who trap shoot or any type of shooting sport. How are they supposed to do that without being accused of attempted armed robbery if they're just in a parking lot? And the eyewitness testimony is just not strong enough. As I already noted, my client is an avid hunter. It's much more likely, based on the facts of this case, that my client was actually going probably to trap shoot. It's unclear whether he was going to hunt, but chances are he was going to shoot at a gun range. And next we need to kind of address what it means for attempt. So the first element of attempt is that the defendant intended to commit the specific offense. In this case, that specific offense would be armed robbery. This just doesn't work because there's no direct proof. There's nothing that indicates that they were going to commit an armed robbery strong enough. It's pretty simple. The second element is more where I think there's some debate. And element 2 states in whole that the defendant did some act intending to complete a course of action or cause a result that would constitute armed robbery under the circumstances, as the defendant believed them to be at the time, and his actions constituted a substantial step. That's what we're going to be really focusing on, is the substantial step towards the commission of armed robbery. The defendant's actions do not constitute a substantial step unless the defendant's entire course of action clearly shows his or her intent to commit armed robbery. My client unequivocally did not take a substantial step towards committing an armed robbery. I've already laid out multiple scenarios where you could have a gun in your car, similar to where it was in my client's case, and not be going to commit an armed robbery. There's not enough evidence from a note. There's not enough evidence from eyewitness testimony that that's what he was actually going to do. I mean, the intent couldn't be more muddled in this case. There's no clear evidence of anything. So I would just like to make some quick conclusions. The note is vague. It could be related to a job. We're told that he's in dire financial straits. Of course he's going to be looking for something that'll make him money. That doesn't imply that he's doing something illegal. It just means that he is trying to get money. And there's nothing to imply that he was going to commit a crime other than some very spotty eyewitness accounts. Like I said before, he's a hunter. Having a gun near him in his vehicle is not unheard of for someone who plans on hunting often or going to the range. I mean, it's just not. Like I said, eyewitness evidence is spotty at best. She's not even really sure of what she heard, and eyewitness evidence is already typically not the strongest evidence. And if she's not even sure what she heard, she said that he was kind of quiet in his response. How can you find him guilty? And finally, just some of the jury instructions I want to clarify. You must be morally certain that my client committed this crime in order for him to be convicted. If your mind cannot rest easy, knowing that an innocent man will be punished for something he clearly didn't do, then you must acquit my client. I'm confident that you will have serious doubts about this conviction and would be unable to find my client guilty. Thank you.